we've got Sarah and Katie of Maple Haven Law. I have a very good background for both of you.
Oh, that's
Okay.
Sarah Hasselton is a 7th generation Vermonter, which is very important on these parts. She earned her law degree from SUNY Buffalo, and she was top 25% of her class. She has worked for private and public sector, and started Maple Haven last year. Yeah, are you coming up almost a year?
Yeah.
Yeah. And Maple Haven Law, if you don't know where it is just up in Waterbury Center where the old Vermont T-shirt building was that nobody probably ever went into, but it's nice and renovated. Katie Reen is the head paralegal. She got her paralegal certification from Northeastern University. She's worked for big law firms in Providence and Boston and Burlington, but spent almost 20 years, with Stackwell and French down the street, and in probate trusts and all things estate planning. So together with Erin, who's not here, but I think maybe is coming, they make up the team at Maple Haven Law. My husband and I just did all of our stuff with them a couple months ago, and it was actually much easier and less complicated than I ever would have thought. So I'll let you take it away. And this can be like a conversational, ask lots of questions, etc.
Absolutely, yeah. Small groups tend to lend themselves to that. So thank you to Katya and to having us at the bookstore. We were here last year on this time, and it was a great crowd. So we're happy to be back. So as she said, we started our law firm just in August of last year. Are coming up on a year, but we've both been doing this type of work for quite a bit of time. Katie and I have known one another, I'm going to date us a little bit, but about 20 years. We have shared nieces, even though we're not biologically related to one another. It's a very Vermont thing, but that's just that's crazy. And they're always very excited as they've, become 18. One of their graduation gifts is estate planning documents, so that's really exciting and joyous to them. They're like, great, those aunts are really fun. So yes, thank you for coming. We are going to be talking about all things estate planning and trying to dispel some myths and answer any questions you might have. When we talk about estate planning, a lot of people make the assumption that we're talking about end-of-life planning, and that couldn't actually be more untrue. That's a component of estate planning, but any responsible estate plan is also going to construct documents that help you continue to live your life just like you do now in the event of unforeseen circumstances. And then obviously at the latter part, we are talking about end-of-life planning and distribution of assets. And one of the biggest goals we have when we're talking about estate planning, at least relative to our Vermont clients, is avoiding probate. The probate process, and I do a ton of probate work. We have a lot of clients right now in Waterbury. It is horrible. In my estimation, it's extremely time-consuming, very expensive, and it just tends to add a layer of complication when people are grieving that is unnecessary and can be avoided. So that is something we endeavor to do, and Katie's going to talk a little bit more in detail about why that is and how she kind of got into estate planning in general.
Sounds good. So I am Katie, and I got into estate planning because I was working so much on probate. I had a civil litigation background, and when I was working on litigation, I was also working on a lot of probate matters. And when I was working with families in probate, as I sat with them day after day during their grieving process and working with them through the probate process, as they are grieving and crying and spending tens of thousands of dollars going through the probate process, and the time, how time consuming the probate process is in Vermont, I was just devastated. And I would leave work every day crying, and I would just say to myself, this could have been avoided. Like, their parents could have easily avoided this for their kids. The spouse could have just done it, their estate planning, and if they did it properly, this could have been avoided. What is probate? Probate in Vermont is if you pass away and if you have one asset that is titled in your name, or any assets titled in just your name, that asset goes to probate court. and it needs to be probated. You have to file an inventory, and your heirs at law or the beneficiaries in your will, if you have a will, are all involved in that probate process. And a typical probate process in Vermont, if you own a house and a few assets, is approximately 2 years or more. The filing fee alone for a probate process in Vermont is typically more than an estate plan.
The reason for that, just to touch on that, is that when we talk about filing fees in probate in Vermont, even if nothing is contested, in order to just have the court administer your estate and dispose of your assets, they charge a fee based upon the overall value of your estate. And with houses being what they cost in Vermont right now, it's nothing to see, easily a $500,000 house, probably more, especially in this area. And that's what Katie's talking about. The fees are going to be thousands of dollars, even if no one comes out and contests that estate.
So my last, one of my litigation clients I had, Mark, he had a settlement from an accident that he was in. And I said to Mark, make sure you do your estate planning. And he said, yep, I'm going to do that. And, it's one of those things that you just kind of put off, right? And he had 2 daughters. And a few years later, his 2 daughters show up and hire me to do his estate. Mark had a mobile home, land, and a couple of vehicles and 1 bank account. I get a little emotional. I cared very much for Mark. And the filing fee, after that estate was done and working with his kids, our attorney's fees were $25,000. And the whole entire time, I just kept thinking, these kids could have just had all of Mark's assets immediately upon his passing. And they had to wait over 2 years to get his assets. I cannot do litigation anymore. I have to switch my area of practice. And 15 years ago, I did that. And I am making it my goal to make sure that I can educate as many people as possible. And I have educated myself, and I take as many seminars and work with as many people as I can to know everything I possibly can about estate planning. Because when I see a spouse come into our office because they don't have the proper estate planning, and their spouse is in a nursing home and they need to apply for guardianship for their spouse because they can't take care of proper documentation or to fill out forms, and all they needed was a power of attorney. Simple things throughout your lifetime with proper estate planning is all that's needed, instead of long drawn out probate processes. Probate courts are extremely overwhelmed, and they don't just handle estates. They handle guardianships, they handle adoptions. I mean, they handle so many different things, and it takes an enormous amount of time sometimes to even just get appointed as an administrator or an executor of an estate. And people are getting upset with us because of the process when we have no control over it. So we're here to talk to you about how that can be avoided.
And Katie touched on the fact that the probate process in Vermont just being so cumbersome and time consuming, and how the assets, when we talk about probate, that end up in probate are titled assets. So a lot of times we'll have clients that will call us and they'll say, well, I don't need to worry about that. I have a will. My assets aren't going to go through probate. And that is not accurate. So even if you have a will, the pursuant to Vermont statutes and rules, with a will, a basic will with assets that are titled in your own name, that still has to be approved by the probate court. Another thing people will tell us is, well, I don't have to worry about that because I have all I have is my retirement account, and my wife is on my retirement account, and then my kids. And with careful beneficiary designation, probably everyone's familiar with beneficiary designation on whether it's life insurance or investment accounts, etc. It is true that if you designate beneficiaries and if they are alive at the time of your passing, that passes outside of probate, meaning the judge isn't going to have to approve that. The problem with that approach, and I've seen this play out too so many times, is if a beneficiary predeceases you or is a minor, minors are not entitled to or not authorized to inherit property or assets in Vermont. So I've certainly had cases where people thought they were doing the right thing and they named their spouse, and then both spouses simultaneously passed. There's a car accident. And then not just for a moment where you're closing out probate within 18 months to 2 years in the ideal world, but I've got a 10-year-old, and that 10-year-old, you're in probate court for the next 8 years, filing annual accountings. You're getting approval from the court for any expenditure that is going to be necessitated. And probably more than even traditional probate estates, when I'm dealing with minor guardianships, as a result of someone's passing, that is probably the most heartbreaking undertaking I have had. And the reason for that is so many times I had a case with a woman who, through a horrific set of circumstances, she has her nephew now who's 10 living with her, and he inherited quite a considerable amount of assets. His parents owned a home, there was some life insurance, and she has 2 kids of her own and said, okay, I've got to retrofit my house, I've got to add another bedroom, and I'm going to have the court approve that. I said, no, you're not. And she said, what do you mean? And I said, that money is for him. The court's goal when you have a minor is to not utilize those assets. It's to set those assets aside and preserve them until he's 18. And a lot of times people will make the assumption when I'm dealing with somebody who's dealing with minors' assets, I'm going to take him to Disney World and I'll put in that expenditure. Of course, his parents passed away. He wants to go on vacation. Those are just not expenditures that the court is ever going to approve. And if that would be your intention, if you had beneficiaries who are minors and you would want to utilize your assets for those things, there's ways, again, that you can ensure that are just not going to be addressed by traditional estate plannings, like, estate planning documents like a will. So it's really important, especially even with careful beneficiary designation, if there's ever going to be an instance where you possibly have a minor beneficiary, in my opinion, it's absolutely fundamentally crucial to make proper plans.
Another common misconception, well, I have a spouse, everything will go to my spouse when I die.
Yeah.
No.
Well, and to expand upon that, so for jointly titled assets, that is true. So if you have a house that you own as what's called tenants by the entirety, husband and wife, or even joint tenants with rights of survivorship, that will pass to the survivor. But it is not true for anything else. If you don't own those assets as joint tenants with rights of survivorship, those assets end up in probate. And we have a lot of cases that we handle where, a spouse had a separate bank account that no one realized or no one knew about, or vehicles. I know this happens in my own house too. My husband can't get to the car dealership with me, so I'm signing all the paperwork on my own. If something happened to me and I own my car just in my individual name, my husband would have to go to probate to deal with that. And it's just a fuss. And actually what we tend to advise people, and this sounds obscene and insane at the same time, people will call me and they'll say, well, there's a bank account with $5,000 in it that I didn't realize my wife had, or there's a vehicle. And my advice generally is if you're going to use an attorney, don't bother to even probate that asset. It's just not going to be worth the liability that you're exposing the estate to, and the fees that you will incur to probate those assets are going to far exceed the value that you receive in return.
So what does that mean? You don't probate it?
So I abandon it. So what will eventually happen is, if it's a bank account, as an example,
Unclaimed
it will
property.
go to unclaimed property.
Oh, wow.
It's better to just do that instead of paying for probate.
Yeah.
What happens to unclaimed property?
It sits there and then
Eventually, there is an administrative process that you can pursue after years and years and years.
yeah.
But yeah, it's not typically going to be worth it to try and recoup those assets.
And then my last one, and then we can move on, because this is one of my favorites. So we call ourselves estate planning nerds.
We are.
So
I'll own that title.
yeah. If you have a beneficiary on an account and they predecease you, that asset does not revert back to your estate.
Mm-hmm.
it actually goes to that beneficiary's estate. A lot of people don't
Can
think
you say
about that.
again?
So if you list a beneficiary on your account,
Yeah,
but that beneficiary predeceases you,
okay.
someone would have to open an estate for that beneficiary's estate. It doesn't
But
revert
that's
back to
reversed.
your estate.
Even though it was yours.
Correct.
Yeah.
Okay.
Yeah.
So doesn't
Yeah.
this all go to the next person?
But if there is no next.
Right.
Yeah, so that's a good question, and so far, you said, hopefully everybody heard, does it go to the next
Yeah.
person? So the short answer to that is
Oh.
it depends. I'm gonna give you a lawyer answer, right? So if that person had their own estate planning documents, a will, a trust, whatever, it would follow whatever the terms are. If that person didn't have heirs, or had no documents in place, what are called the laws of intestate succession apply. And really, that's just this old, term. And what it really means is your closest kin. So if you die without a will in Vermont, what will happen is if you have a spouse and that spouse and you share children, there's no separate children from prior relationships, your spouse will receive everything. If you have no spouse but have children, your children receive everything. If your spouse and children are gone, your parents, your siblings follow down your lineal line to closest descent. And some people will be like, okay, that's fine. And we hear a lot of people going, oh no, my brother Bob is never going to receive my assets. So it's really important. And actually, a lot of the estates, for whatever reason that we have right now, are sibling estates where like a sibling died, all the parents are gone. And so we've literally, in one I had, I think 29 heirs because a lot of their siblings were deceased. It was really elderly people, and now there's grandchildren and great grandchildren, et cetera, et cetera. And those are the most exorbitant in terms of cost, because anytime you do anything within the probate realm, even if everything is agreed, you have to get everyone who's an interested party, you have to get their consent.
Oh, wow.
And so you're sending around 29 pieces of paper anytime you go to take an action. And that's really the reason I feel
Cost.
really bad. A lot of times people, I think we're just bilking them for costs, and it's truly because the rules are so very archaic and haven't been updated. And you are having to notify so many individuals anytime you take an action on an estate. And the way probate works is everybody agrees, or if even one person doesn't agree, you have a hearing on every single issue. And in families where things are divided, what I find is there's a holdout, at least in one instance. And so you're doing lots of hearings for even things that you just shouldn't really have to be doing hearings about,
So it doesn't
unfortunately.
work like the movie Knives Out where everyone's in the same room when they're all young.
No, that is a misconception
Yeah.
too. People are like, "Are you gonna read my will?"
Yeah,
If
and we're
you're
like, that's
reading-
only in the movies.
It's only- doesn't happen that way in
I
Vermont.
just wanted the people to come.
Yeah. Yeah,
To the big table.
yeah.
Yeah,
Hasn't worked out.
yeah. Yeah, so that's all the reasons we avoid probate. I'm going to touch a little bit more in granular detail about the documents that we would recommend everybody have in place for lifetime. So really important documents: an advanced healthcare directive. That is a document where you appoint an agent, they're called, and that individual is allowed to make medical decisions for you if for some reason you could not make those decisions for yourself. In Vermont, we're really lucky that for kind of quaint state, and Katie and I have both had to act both professionally and personally for people. And my experience has been, if someone is there in the room, the doctor is going to want to defer to any live body because they don't want to have to make a decision themselves. But in other states, I can certainly tell you from my personal experience, that's just not common. My brother was very terminally ill like the last year and ended up passing away, and he was in Boston. And thank God we had documents in place, because those doctors wouldn't talk to any of us without referring to his documents. So it's very important that you specify in those documents who your agent is so that somebody can make decisions for you. And the other reality that we're experiencing is right now, even in Vermont, funeral homes are really wanting to see those documents to release remains or to know what your last wishes were. So exceptionally important. Do you want to talk about the durable power
Sure.
of attorney?
The general durable power of attorney is a very important document. It appoints an agent or agents to for you to act in financial or legal matters. You can appoint co-agents. You can appoint just one agent. You can have this effective upon incapacity or effective immediately. If you do have it effective upon incapacity, a doctor does need to declare you incapacitated. So we rarely see that. We have them mostly effective immediately, so someone can help you really in any financial or legal matter. Postmasters are asking for this now to get packages. Yep. They're, let's see, financial institutions. They want the agent's license to match the document with their address and phone number. The statute was updated
2023.
2023. So there are free forms online. I appreciate that there are free forms online those are not usually very helpful for this particular document. And so, just you probably want to use an attorney for this document especially.
Yeah, the other thing I would just point out about the durable power of attorney, Katie had mentioned like proceeding with guardianship in the event
Yes.
of Alzheimer's or dementia. And of all of the documents we prepare when we're meeting with estate planning clients, what our clients tell us is the document that they utilize most frequently is that durable power of attorney. And I have certainly seen, I do a lot of involuntary adult guardianship as well. So important. If you end up, as we have an aging population with assets and you need someone to be able to take care of you if you're in a care home or in a long-term care setting, one of the things that they will ask is, do you have a durable power of attorney? And that's so that someone, if you were to lack capacity, can utilize those assets to continue to take care of you. Also fill out long-term care application, the simplified 17-page long-term care application that is the Medicaid process. So super important document. As Katie said, we're definitely seeing more formalities being enacted by financial institutions, and I understand that as we have identity theft and other issues that sort of surface and percolate more frequently. They want to do their due diligence and make sure that whoever they're speaking to has the requisite authority. So
a
extremely important.
A lot of financial institutions want to see these updated every 5 to 7 years as well. So we're frequently updating those a lot for clients. I was going to say something else too.
And can you just say again, power of attorney is sort of like all financial and legal matters
Yes.
on your behalf.
Yes,
correct.
exactly.
Financial and legal, so not medical, not health.
No,
related.
Right.
so the healthcare directive
That's-
dictates
that is-
that,
okay.
and then the durable power of attorney does dictate legal and financial. Other states, you'll see documents called like a medical durable power of attorney. Vermont, we just have changed the language, so now it's called an advanced healthcare directive. It essentially does the same thing. And as Katie said, there's free forms both for the durable power of attorney as well as the advanced healthcare directive. So the state of Vermont has both a long form and a short form healthcare directive. Again, sometimes you do get what you pay for a little bit. The point of that form is really to ensure that whoever is going to have to make that decision for you, if you can't make it for yourself, is informed about what your choices would be. And so my experience with those two forms is they just aren't super, the explanation and what they cover therein isn't super fantastic and detail oriented. Our form is truly like painstakingly probably detail oriented.
Yeah.
It will really drill down on like, okay, if you needed palliative care, would you want feeding tubes? No. Would you want IV hydration? Would you want just pain medication? The goal being so that the person having to make that call isn't having to guess. And then another sort of point of clarification that sometimes comes up or people will ask questions about is DNRs or cold orders, sometimes they're called. So that's a cessation of life-sustaining treatment order or do not resuscitate orders. Those can only be prepared by a medical provider under Vermont law. So an attorney's office isn't going to be able to make that document. So if you did have a situation where you were a loved one, was terminally ill and that was important, you would have to talk to your medical provider about preparing that form.
Yeah, on the form that I filled out for them, I drilled down to like, if I am this, then I want this. Like it was very site specific.
Yeah.
And what is that form called? The
That's the
medical one?
advanced healthcare directive.
No, I mean
Oh.
the one that's through medical only.
Oh, do not resuscitate,
Oh,
order
okay.
a cool cessation of life-sustaining treatment. They're kind of called interchangeable terms. So those are sort of what they're commonly known as. Yeah, I don't know if I told Katya this, but I was meeting with this sweet old gentleman one time, and he was filling out his healthcare directive. And he looked at me and he goes, well, I don't know, do you think I should get the feeding tube? And I was like, answer that question for you. Like, it is my least favorite form because it asks you to make really horrific decisions in a vacuum, no less. But yeah, I think it's so important.
change it.
It is,
So
it's
Yes.
totally changeable, absolutely. As are most of the forms that we, recommend and have prepared for people.
Okay, but one question on that. You can always change it. Is that like you're paying legal fees whenever you have to change it?
Yeah, I mean, I think it would really depend on what you're changing and how substantive it is.
Okay.
So when we draft forms, we try and draft them in a way that lend themselves to being really flexible and grow with you as you age.
Okay.
That's not to say they cannot be changed. What I typically will recommend to people is if you have a major life event, a birth, a death, a marriage, it's a good time to just review and say, like, a check-in, like, should we be making any changes? But they truly are designed to grow with you. That's our goal.
Forget it.
Yeah.
Okay.
Do you want to talk about the healthcare directive registry?
Sure. And also, I just want to mention before I forget, because I keep reminding myself to say this, the healthcare directive and the general durable power of attorney, those are the gifts that we give to everyone when they turn 18.
It's true.
Because when you're 18, your parents can no longer call your doctor for you or make that deposit in your bank unless they're co-owners on the accounts. So we are seeing more and more high school graduates coming in as clients when they are turning 18. So 18, healthcare directive, power of attorney.
That's the thing, this is like not an age thing, like.
No,
Last year I
18.
was like, my mom doesn't like talking about it, cause she's like,
Right.
don't talk about me dying, I'm not old, and I'm
Right.
like, it has nothing to do with your age.
Right.
Yeah.
18 years and older.
Mhm.
Everyone needs some form of estate planning.
Yeah. Registry.
Advanced Healthcare Directive Registry is a registry out of New Jersey for Vermont that you can register your healthcare directive. And if you were, for example, in an accident anywhere in the United States, police officers, EMTs, hospitals can access this database to be able to access your healthcare directive and would be able to call your agents and let them know that you were in an accident, would be able to know what your wishes are. You are provided with an ID for your wallet and a sticker for your license with an ID number on it. And anytime you update your healthcare directive, you just make sure that this registry is updated as well so that it's always, with the correct information.
What's it called again?
Advanced Healthcare Directive Registry. And you can just Google that and you'll get the form, the registration form.
So we focused a moment ago on the documents that are really designed to help you during your lifetime to continue to live life just like you do now in case there's a unforeseen circumstance. In the latter part, we're going to be talking about documents that are really more focused on end-of-life planning. So one document that a lot of clients will ask us about is something called an enhanced life estate deed, or sometimes it's called a ladybird deed. I don't know if anybody's ever heard of that term. But essentially what that document is for real property. It's a deed just like you have now if you have a house. But what it says is upon my passing, it says actually two things. One, during my lifetime, I can sell my house, mortgage my house, finance it, do with it whatever I want. And then upon my passing, my house goes in equal shares to my two children. If you have that type of deed, probate would not be required for your house because the house will pass outside the probate realm because your deed itself specifies who will receive your assets. And sometimes people will say to me, like, okay, if I've got that deed and I have really careful beneficiary designation, am I covered? And my answer to that is a lawyer answer, perhaps. That can be an okay approach. I tend to think that approach is sufficient for people that are pretty elderly. They don't have a lot of assets, and they've got bank accounts, and their adult kiddo is on those assets, and we know that there's probably not going to be an issue where somebody predeceases them. But again, the problem with that approach is it doesn't plan for the what if scenarios. What if the people that you've specified as receiving your house after you pass, called the remainder men or the remainder people, predecease you? And then you're sort of back into the same cycle that we talked about at the onset as to, probate, and that it hasn't been avoided. So then the question is, well, how do we avoid this? And the most comprehensive way currently for most of our clients to avoid probate is going to be to create something called a revocable living trust. A lot of times I'll say this and people's eyes will glaze and they'll say that's something the Kennedys or the Onassis need, but not me. And it could not be more untrue. The type of trust that I'm referring to, again, a revocable living trust, is most useful for people who have worked hard, have some assets, maybe aren't multiple millionaires and can take advantage of all sorts of other fancy bells and whistle documents, but want to try and preserve their assets from the probate realm. And then there's some other benefits too. I touched a little bit on Medicaid, and long-term care is what I'm talking about specifically with respect to Medicaid. So with Medicaid, and I could do an entire seminar on that, I won't bore you with the details on that, but Medicaid is really a two-step process. One is, do you have assets, if you need long-term care or nursing home care, do you have assets that are so low that qualify you for Medicaid? We can talk about all sorts of, nuances to that, but if the answer to that is yes, if you had, very few assets, and in Vermont, a lot of times people's largest asset is their house. In Vermont, Medicaid will say, we'll exempt your house up to about $750,000. Meaning if that was the asset that you owned at the end of the day and you needed nursing home care, they would say, sure, you're eligible. Where Medicaid gets most people is on the back end. It's what we call recovery. So in my example that I just mentioned before, you've got a house, it's worth, let's say, $600,000. Medicaid says, sure, you're eligible. You go into a nursing home, you're in the nursing home for 2 years. We know that nursing homes on average in Vermont are about $150,000 a year. And so what happens is with traditional probate, your probate estate opens, and DEVA, which is the Department of Vermont Health Access, they are the first in line to file a claim against your estate. So they would say, yep, you were eligible. You had $300,000 of care for the last 2 years, and we're going to file a claim against your house to recover that. If the house is the only asset that's going through probate, the sad news that we're faced with telling so many clients is you have to sell that house, because that is an asset of the estate, and Medicaid is entitled to get reimbursed for the care that they were paying. So with a trust, the benefit is that no probate estate opens. And so in addition to avoiding all the fees and the fuss that we talked about, another significant benefit is that it really does help insulate your assets from Medicaid attachment. There is no mechanism by which Medicaid can attach, or other creditors, because no probate estate opens. In addition to Medicaid, I will also tell you that when a probate estate opens in general, there are national databases that credit card companies get alerted to. So I have yet to see a case where, a credit card company doesn't get notice once a probate estate opens, because there's just these databases, and they file almost instantly. You can be guaranteed that if you owe somebody credit card debt, they're going to file a claim against your estate. So with the trust, because probate is not required, it does provide that layer of insulation. A trust operates and looks and feels much like a traditional will. It's going to name your beneficiaries. It's going to name the person you designate, called a trustee. It's like an executor to dispose of your assets after you pass away. Again, the beauty of a trust is that trustee does not need any permission from a judge. They don't have to wait 4 months. They don't have to do anything. They have the authority upon your permanent incapacity, or if you pass away, to dispose of your assets as you've outlined in that document. This particular type of trust, again, the revocable living trust, is what we call a disregarded legal entity, which is just a fancy way of saying that during your lifetime, there's no tax consequence. It's your own social security number. You don't file for a separate EIN number or a trust identification number. You live your life just like you do now. And then upon your passing, the benefit is you can avoid probate because your trust owns your estate. So you don't need the probate court to control that. So it's an extremely beneficial tool One that just it offers so many protections. The other benefit, we had talked a little bit about minor beneficiaries or how that looks. So a trust, unlike a will, can say, well, you know what, I have 2 children. I would want my assets to go to my 2 children equally if I die. But if something were to happen to one of those children, I would want it to be my grandchildren, and they're minors. So the trust can very finitely craft and say, I want that trustee to take that money that's for that minor grandchild, and I want them to hold on to it, and I want them to invest it, manage it, use it for their health, education, maintenance, and support until they are no longer minors. And actually, usually it's not even minors. Most of our clients will say, please don't give my 18-year-old grandson $300,000 of assets. So you can customize, I would like a quarter to go to them at 21 and a quarter to go to them at 25. Or I want that just to be used for educational purposes. You can really very carefully control. And again, then you're ensuring that probate is avoided in the event that you have a minor beneficiary. Another, thing that presents itself quite a bit is sometimes we don't have minor beneficiaries, but we have clients who have children or beneficiaries who struggle with substance use disorder, who are just not great with money, etc. And again, there's a mechanism with a trust that allows you to still set aside those assets for those beneficiaries, but really carefully and thoughtfully decide how assets are going to get into their hands. And some clients will say they can't have money in their hands directly, but the trustee can use that money to take care of them during their life. That's hugely, hugely important, and this point cannot be overstated enough. If you have any beneficiaries who are receiving means-tested benefits like Social Security, you do not want large sums of money to go into a Social Security recipient's pocket or coffers, because it will likely disqualify them. So there is language that can be put in these documents that ensures that their eligibility is preserved, so that we don't kick them off and subject them to losing health insurance or ongoing benefits. So lots of benefits in these type of documents. As you might imagine, there's a multitude of different trusts also that can be created. The type that I am talking about, again, it can be changed during your lifetime. Usually it's appropriate for, I would say, the vast majority of our clients. If I have situations where I have clients who have extreme wealth and are going to exceed the estate tax thresholds of like $24 million or more, we're doing more sophisticated estate planning in those instances. But for the vast majority of our clients, that's just not necessary. So that is sort of trust in a nutshell. You can talk about the pour-over bill.
Sure. You can also omit people in a trust. So who was it, Bob? I don't remember the sibling that you referenced earlier.
Yeah, my favorite
But you can omit people in a trust. So with a will, or if you pass away without any estate planning, your heirs at law would need to be involved. People contest, people try to just create problems. And then there's headaches and drama, and then there's already so much going on with that already in probate. So with a trust, you can just omit people, and with a trust, it's just who's involved is involved typically. So it is what it is, and people can try, but
yeah, and you can omit people in a will too. The difference is they're still entitled to notice as an interested party.
Yeah.
That's not the case with a trust. Only the beneficiaries are entitled to notice.
so with a trust, there is still a will. It's more of just a backup, basically. It's called a pour-over will, P-O-U-R, and basically it just states, my beneficiary is my trust. If I forget, or if there is a stray asset, if I forget to transfer an asset into my trust, or if I pass away and there is an asset in just my name, I will transfer that into my trust. So you're going to probate those stray assets, but transfer them into my trust as the beneficiary. And that's where we kind of decide, well, how much is that asset worth? Is it worth probating? We know someone that never puts their vehicles in their trust,
And they have a
And
fleet.
and so there's going to be like 15 vehicles to eventually transfer over into a trust when that person passes away. But you can, moving forward, when you have a trust, you just purchase them in the name of the trust going forward. So when you set up a trust, it's called funding. So there's step 1 and step 2. You set up your estate planning, and then you fund your trust. You transfer all of your assets either into the name of the trust or set up the beneficiary of the trust. And then moving forward in your life, if you purchase a new house, if you get a new asset, you just set those up in the name of your trust moving forward. And then hopefully that will is just never used.
Yeah, it's a backup. It's one we hope to never be used. And in terms of what Katie was just referring to about what we call funding. So step 1 is going to be, if you proceeded with a trust, we would draft that, you would execute it, you have a trust. I can't speak to other firms, but at our office, we would take care of, if you own real estate, we would actually prepare a new deed for you at the time you came in to sign, so that any real property interests you own are owned by the trust at the time of signing. Same with your tangible assets. We prepare, it's probably the simplest of all the documents. It's 1 page, and what it says is essentially all my things, my furniture, my jewelry, my artwork, etc., that I now own or may futurely acquire, is owned by my trust, so that probate is not involved over, grandma's antique grandfather clock.
Because it's always about the stuff.
It is, it's true. And then all of the other assets, so when we meet with people, we really carefully go through all assets. We want to have a really good sense before we make a recommendation, because there's a ton of different estate planning options out there. We want to make sure that we're making the best recommendation as applied to you and your assets. So we will go through and we'll say, where do you bank? And do you have CDs? And what type of investment accounts do you have? Do you have cryptocurrency? What do you have for titled assets like cars, boats, trailers, etc.? And what we're trying to do is understand that funding piece, which is where we're thinking, okay, for specific assets, as Katie said, the goal ultimately is going to be that your trust is either the owner of every titled asset you own or the beneficiary. And we give you very specific information as to which that is, depending on each specific asset you own. And then ultimately, if there were what Katie said, a stray asset that was left outside the trust or did not designate the trust as a beneficiary upon your passing, that will is just there as a backup, just in case, so that we don't end up with an intestate estate, which is just an estate without a will. We don't want that to happen. I'm trying to think what else. I don't know. I'm going to pause for a moment and see if anybody has questions. I feel like we just regurgitated a lot of information to you, and I want to make sure if anybody has specific questions.
I have a question. Why would someone set up a revocable versus an irrevocable
Yeah, that's
trust?
a great question. So there are, and there's multiple types of revocable and irrevocable trusts, but irrevocable trusts are typically reserved for individuals that are trying to shift wealth away from their countable assets. So for that ultra wealthy, example I gave, so if you have currently, we don't know what's going to happen, we're sort of living in the upside down as it is, but currently we know the estate tax exemption for married couples is roughly $26 million. If you had assets that exceeded that, you don't want to get taxed because on those assets, it's 40% roughly. So we're trying to take some of those assets away from your countable estate, and then we would shift them into an irrevocable trust. The distinction between an irrevocable and a revocable trust is that you no longer own those assets if they're in an irrevocable trust. So that might be a reason. Another reason is if you did have a beneficiary who had some significant special needs, and you just knew that they were never going to be able to manage assets on their own, and or you didn't want those assets to count against them, that might be another reason we would do that. Also, if I had a situation where somebody comes to me and they say, you know what, my wife got diagnosed with ALS or early onset Alzheimer's, and there's going to be a situation where Medicaid eligibility is definitive, at that point I might want to try and reduce what are countable assets for Medicaid, and I could put those in an irrevocable trust. So those would be some reasons that you might consider that as opposed to a revocable trust, which, just as the name suggests, has a lot more flexibility. If beneficiary structures change, if life happens, you can make changes much more readily to a revocable trust, whereas with an irrevocable trust, much like it sounds, you're going to court to typically make those changes.
I've seen real estate in a family trust versus just
Yeah.
Yep.
individual.
Yeah, that's becoming really common, especially as we see a lot of camps or family homes that are like second houses. So we've done a bunch of those, like a realty trust or a family trust, which is just designed to hold property essentially.
But and what happens if when the person or the one person in that or the person who set up that family trust
Yeah.
dies?
Yeah,
And then what happens to the other, or what happens to that thing that's designated family?
Yeah, that's a great question. So again, the answer is sort of it depends. So what you do is if there was a realty trust or a family trust
Right.
for this property, you have what are called guiding documents that say, okay, our intention is that this is preserved. I'm making this up, but it can be whatever you want is essentially the long and the short. So I've done a bunch where my client will say, my goal is that asset is held onto and preserved for my family. There has to be a majority rule to make any decision on maintenance or upkeep, et cetera. If it's going to be sold, it has to be unanimous. The costs are going to be split by putting this money in an investment account. Sometimes it's like a life insurance policy is going to fund the maintenance costs, and it's going to be invested, and we use the interest or whatever. So it really depends on what your assets are, what your goals are. But it's not uncommon at all, especially as we see a lot more second homes or vacation properties that. Some people will say, my goal is to really preserve this for all of my descendants into kind of perpetuity. And that can be done. That's pretty common.
That actually reminds me, if you own any like corporations or LLCs or rental properties, it's really important to set up a trust and make sure that your trust is the owner or member of that LLC. It's really sad when a spouse passes away and they're like the only member of the LLC and it's just in their name, and then the other spouse can't do anything with that. It has to go through probate because
That's what happens.
that's
yeah.
what happened.
Yeah, I see that a lot. Vermont is like a state built upon lots of little sole proprietorships and farms and family farms. And we have a ton of farm clients for
Yes.
whatever reason where like it's an operational farm, and the person that passed away is the sole member, and nobody can like issue paychecks even until you get a probate court appointment letter.
Can't access the bank account. Can't
Yeah.
a lot of people don't realize that, and so it's such a simple, to us it's a simple thing. It takes us just a couple minutes to draft that document that transfers that LLC into the trust, and could save
Lots of money.
months and a lot of
and more
money
heartache and,
for that
and time.
spouse.
Yeah.
Yeah, I think last year you used an example of someone who had passed away without anything, and they had the house, and no one was allowed to enter the house to turn
Yeah.
off the water, to turn
Yeah,
on
I've
the heat,
had
like,
several with pipes frozen and burst. Yeah.
Wow.
and so then like consequently either fixing that, they couldn't sell the house,
Right.
and then it just like snowballs.
And morphs, yeah.
That's I think what like really was like, okay, we really need to do this.
Yeah.
Yeah.
And the dog.
Yeah.
Yes, you can put your animals in your trust.
Ralph
Yeah.
and Cannoli?
Sadie
Mm,
gets
we
it.
have to acknowledge.
Sorry, Maisel.
Yeah.
I have a question across. I'm thinking that my parents are out of state. I don't live in the same state as my parents. Is there anything as like a beneficiary or guardianship that across state lines, or of all these documents that we're filing, would hold up in other states?
They
I know
do.
there's some specific things you've been mentioning about Vermont.
Yeah. So the short answer, well, again, we're sort of living in the upside down, but right now the rule of law is that yes, we afford full faith and credit. So what that means is any document that was legally and validly executed pursuant to Vermont law should be afforded full faith and credit in any other state or jurisdiction. In terms of, so we'll have a lot of clients, or we have clients that are snowbirds, right? Like they'll stay part of the time in the South and come back in Vermont. So these documents are flexible. They're designed to, move with you. What I typically recommend is if you're going to be spending an inordinate amount of time in two states, it's sometimes good to just do a durable power of attorney and a healthcare directive in both, not because one is not valid, but because when you go to Florida, they're going to be much more familiar with their own state's healthcare directive, and you're just not going to receive as much headache. But absolutely, these documents should follow you wherever you go. And with a trust itself, all of these things are customizable, to be entirely clear, but our general provision says that you are entitled during your lifetime and capacity to change what's called the situs of the trust, which is just where it's going to be administered. So we've definitely have clients that started out as Vermont residents, and I was just talking to a gentleman last week who's moved to North Carolina, and he's like, oh my God, I'm going to have to do my trust all over. No, you don't. You can just file a written documentation saying that your situs is now North Carolina, and you're going to have your assets administered there upon your passing, because that's where he lives now permanently. So yeah, they're designed to be flexible. We don't want you to have to pay us or anybody to modify these every time life happens, right? If it does happen. Whoops.
Can you talk about the the process from when someone walks into the office?
Sure.
And then on the other side too, because those were two things that overwhelmed me. How does all this happen?
Yeah. So I can obviously just speak to our process, not anybody else's.
Sure.
But yes, so normally if somebody calls us, and I will tell everyone, if anybody books an appointment with us and decides to proceed with any type of estate planning, we're going to give a 10% discount for anybody that attends one of these events. So normally what happens is we sit down, we have a really, not really lengthy, it's about an hour typically, a meeting where we do get really specific information about your beneficiaries, your assets, any nuances that we really feel like we should know. Katie always says, and I firmly agree, that if you meet with someone and they say, oh, I'm just going to mail you a form, or I'll email you a form, fill that out, and then I can draft your documents, that is, in my opinion, not the most prudent approach, because I can't tell you how many times I have sat around a table with clients and they'll say, well, yes, I have, this son, and if I didn't have a conversation with them, I wouldn't know that their son was struggling with substance use disorder for the last 8 years, and we can't give that person, a direct, probably not a direct distribution, because that's just, we want to save them from themselves, so to speak. And those forms just don't lend themselves to all the nuances that exist in families. So we ask a lot of questions, and then we get a sense of assets, beneficiaries, what your specific wishes are, what you're trying to accomplish. We then would have to have you sign an engagement letter, because that's what our malpractice insurance carrier requires. And then normally what we do is, if there's anything, because a lot of the questions that we might ask, as you can imagine, are horrific things that no normal people have thought through. So as an example, I don't know if Katya remembers this, but there's a provision in any will or trust. It's called a disaster or a wipeout provision. And I don't know if anyone has ever seen the movie King Ralph with John Goodman. It's kind of old. But he becomes royalty by happenstance when there's a photo mishap and the entire royal family is wiped out. So he's like a seventh cousin 5 times removed, and now he's king. And so we call that the wipeout provision, which is where if you had no descendants or named beneficiaries left, what do you want to happen with your assets? And most people are like, I have no idea, because who would have thought through that? No one. Normal is the answer. But it's really important that we have that information, because not everyone wants default presumptions of Vermont law to apply. Sometimes people are like, no, I want this charity to have my assets, or I want my friend, not a family member. And that's really important information to have.
We also want you to only pay for this once, hopefully, unless you really need to change this. So we give you we sit there and stare at you and give you so we know that you don't have any children yet, but if you had children,
what if you have grandchildren?
And give you all of these scenarios, or give you grandchildren that you don't have yet. And so, yeah.
In fact, there's a gentleman I was meeting with today, so sweet, I adore him, and he met with me initially about 5 years ago, and I remember sitting with him and his daughter, who wasn't quite married yet. I'm like, well, what if you had grandchildren? He's like, 5 grandchildren. I'm like, I'm giving you hypothetical grandchildren, I know. And he came in today, she has twins, she just had babies 6 months ago. I was like, see? But yeah, we really want to get a very, very concrete basis for what your assets and your beneficiary structures look like. We'll follow up with any questions that you don't know answers to. We use all sorts, some people are much more comfortable with mail communication or in-person communication. Our clients are busy and they want email, and we can do whatever. And then we normally, once we get the information back, I would say we're about, on average, 4 to 6 weeks between getting you some drafts. Once we have all the requisite information to be able to complete those. I always tell people this, I'm going to get a sign and I mean it. We tell people, please tell us if an emergency happens, because it is so important to ensure that we're not, doing this for naught. We don't want you to have undertaken these steps only to have to end up in probate. So we get calls for a lot of end-of-life clients or clients that are in emergent situations. So we go to the hospital quite frequently or to the nursing homes. But those are not ideal circumstances to be drafting documents in. So we want you to let us know if there's an unforeseen circumstance, a routine surgery. If you're traveling, especially internationally, we'll expedite you.
If you have a toothache,
Anything.
call us.
Call us. Here's the neon flashing sign.
Do you mean within those 4 to 6 weeks? Is that what you're
Yes,
saying?
yeah, so that it's sooner. Yeah, we want to know if something emergent is going on. But yeah, we're about 4 to 6 weeks to getting drafts, and then depending on if people have a lot of questions or suggestions or revisions, I would say it can be really quick to finalize documents after that period of time, or if people really still need to think about it. A lot of that is just driven by the client, is really sort of what I'm saying. But once that part is done, we then have you come in to sign, execute your documents. As I mentioned, we take care of all your real estate holdings, your business holdings, your tangible property. That's all taken care of simultaneously at signing. And then we then ask people, do you want us to help complete the rest of the funding, it's called, where you're titling your assets so that they are owned or designated as the beneficiary of your trust. And a lot of our clients, after you sign, you will get a really, Katya can attest to this, thick binder. It's called a portfolio. And it will contain a copy of everything you've executed, a summary of what you've executed and what it says, and then what we call our funding instructions or your homework. And it will say, okay, you told us that you had accounts at NEFCU and that there was a CD and an investment account. This is what you're going to do for those accounts. If you choose to do it, if you want us to do it, that's fine too. But our instructions are pretty explicit, and most of our clients will say, I don't need to pay you to do something. You gave me the information as to how to do myself. And then once you title or are complete with those assets, then you're done. I mean, your trust is what we call fully funded, and it has all the safeguards that we mentioned about avoiding probate and ensuring that your assets pass outside that process.
And we don't need you, we don't want you to pay us for that. Like, we give you very specific instructions. Go to the DMV website, print out form number, blah, blah, fill it out this way. Like, we give you such very detailed instructions. You can call us and we're available to answer any questions that you have. But we've done hundreds, thousands maybe of estate plans. And we give you very specific instructions based on your situation, because we've met with you and know you now. So that's our process anyway.
Yeah.
And what's generally the cost of
Yeah.
that?
I'm being recorded. I can't be held to this. So again, I can't speak to any other firm. So I can tell
Especially
you,
Burlington firms.
if it is something like you've got a house and some assets, and your intention would be that I want all of my assets to go to my spouse if they survive me, and then to our children in equal shares, and if they both predecease me, then to my grandchildren if I have grandchildren. If it's something fairly straightforward like that, then for the documents that I mentioned, for the deed work, etc., I would say a single person is about $1,500 approximately, give or take, and then a couple, it doesn't double the cost, maybe $2,500 on average. And then some of that is obviously going to be factored by how complicated, whether people want. I had one client one time, she was so sweet, she was from England. I think we were on version 22 of her trust before not because we had made mistakes. She's like, oh, I don't know. I wanted to go to my other cousin. And okay, but
And that's when we stopped doing flat fees.
Yeah. Yeah, we can't do that anymore. So yeah, a lot of it is really going to be driven by, the client, but for fairly straightforward plans that are designed to just give assets to spouses and beneficiaries, I would say that is the ballpark.
I guess I'm shocked that's more affordable than I thought.
me too.
Sorry, didn't mean
Yeah.
to interrupt.
Yeah.
I mean,
I mean,
especially compared to the probate situation.
Yeah.
Yeah.
10,000, 25,000,
Yeah.
like, jeez.
yeah, there's a house
Years
right now
later.
in Waterbury that we're dealing with. God help my soul. So it's siblings, and I think we
So
only had it
sad.
since September.
No, December
I'm
31st.
sorry, December. It's not even.
I
that
know.
long. And I think those fees are
Yeah.
over $30,000 at this point.
Yeah.
It's insane.
For the little house.
It's not a man. I mean, it's a sweet little house, but yeah, we're not talking about the multi-million-dollar home by any shape or form. But they can't get along, and so I think when I looked the other day in my inbox, I have 782 emails just since December on that one case.
For that
Just
one.
that.
What?
Yeah.
Oh my god.
Yeah, there's been a lot of
And
And
so
that's
all, like,
trauma.
those types of fees would come out of,
Of the estate.
right, and so that means the beneficiaries are not
Yeah.
getting those money. I mean, they'll still be money, but
Sure.
they're getting less than they would otherwise be entitled to.
so once, and I'm so fuzzy on this, so like, once we have all of our stuff, Chris
Yeah.
and I, and let's say disaster strikes and we're no longer here, what happens?
Yeah. Well, so I can give you just like the woman in Hyde Park. So we were working with a client in Hyde Park. She was end of life. We did her estate planning quickly. Her daughter called me screaming at me, "Why would you have done this for my mom?
We
She
did a
does
trust."
not need a trust. I cannot believe that you would have done this for her." Like, I mean, I was on vacation. I kept talking to her. Like, I promise you, I would never do anything for a client that they did not need. And the next day, no, it was like a couple days later, she called me and she was crying and she was like, "I'm so sorry. I now understand why you did this." She had her mom's house sold. She had an auction, her check come in and auction the personal property. She had like the investment accounts split up
Done.
between
Yep.
her and her brothers.
Like the next week.
She had the bank accounts divvied up between her and her brothers, and the house sold, all done within 3 months. She wouldn't have even been appointed by the Lamoille County Court
Probably not.
before then.
Wow.
That's like a real life example of how amazing trusts are.
Yes.
So like we don't have kids, so
Yeah.
our beneficiaries are not our children.
Right.
Yeah.
One is a friend, one is a charity, yada yada.
Yeah.
When you find out that a client has gone,
Yeah.
then you guys make the contact for,
It's
or is it
It
the
sounds
executor?
morbid, but we regularly monitor the obituaries just in case.
Sure.
We
I
also
mean,
will
yeah.
ask our clients when they come in to sign, okay, who do you want to have copies of everything? When do you want to be,
Yeah.
when do you want us to notify your successor trustees? And then we try and get contact information so that if we are aware that somebody has a pass, that we then can proactively reach out and say, hey, give us a call if there's any questions about that. And then your successor trustee upon your passing has authority to follow your wishes that day. I mean, truly that moment.
That
It's
very
kind of-
moment.
Most of the time when people call us because there's a question, it's actually just to reassure them that they have the
Yeah.
authority to do what they're best at.
Right.
What do you mean I can sell the house? Don't I need a approval? No. You can
Yeah.
Go hire a realtor. You can
Yeah.
do that.
Typically, we always make that like a very priority appointment. Historically, it's usually like, do you want to meet tonight? Because that's trauma. So, I was working with a woman in Jeffersonville, and her husband died a few months before, and then she suddenly passed away, and she had 3 kids in her 30s. And one of the kids called me and she was like, "I don't know if you recognize my name, but my mom just died last night." And I was like, oh my gosh, like, I'm so sorry. Do you want to meet? And she was like, yeah, I'm very overwhelmed. I don't know what to do. And she was a trustee. And I said, okay, well, you're the trustee. It's up to you if you want your siblings to come, but I can make, whatever work for you. Do you want to meet tonight? She was like, how about tomorrow? Sure. I canceled my appointments for the next day. And I met with her and her siblings. And I was like, okay, you're the trustee. This is what your mom set up. Here's what your responsibility is. These are all of the assets that I know that your mom had at the time that we met. And she's like, so I just can hire a realtor? I was like, yep. It's more of like, yes,
Reassurance.
that's what you can do. And she would go to the bank and then she would be like, there's like sometimes a lot of pushback just because depending on who you get at a financial institution, like that person that you're working with might be new or might be in the training process. So I'm like, if you have any questions, just call me. So then I'm like, okay, well, put that person on the phone and let me explain it to them because they're grieving during this process. They're very overwhelmed. It's just like reassuring them, yep, you're doing a great job. Because there's a trustee, we can be the trust advisor. Sometimes we're the trustee. Mm-hmm. So a lot of times we're the trust advisor and we can just give them guidance and and just let them manage it.
The other thing I didn't, what Katya just mentioned about the house with the frozen pipes reminded me of this. In Vermont, with a regular estate, so a traditional estate, if you have $45,000 of assets or more, which is really nothing, right? You have to do traditional regular probate, which means publishing notice to the creditors. Minimum, you have to publish that for 4 months, and so minimum, I mean, that would be like a grand slam. You're going to be in probate longer than that. But even if nothing is contested, and assuming you get in and publish that notice on day one, it's going to be open at least that long and probably a lot longer. So that is, as Katie said, like that other lady, everything was sold within a time period that's shorter than statutorily you would have to have notice to creditors. So, yeah. Any other questions?
If you pass away, sorry, I know there's a lot, and I'll stop talking eventually, but if you pass away without proper estate planning and you have a child, the court will have the executor or administrator set up a trust for the child if they're under 18. And then every year you have to provide an accounting to the court, every single penny that has been accounted for that child. So there's another reason why anyone that has a child needs,
or a potential minor beneficiary,
needs a trust.
Yeah.
Do you have like gift cards so we can buy this?
Gift cards? Oh, that's a great question. Like, what do you mean, like to give somebody? We do actually try and do.
18-year-old or
I mean,
sibling or parents.
yeah,
or
we've
something.
definitely had situations where like my own parents included. I'm like, I got to do this for my parents. So yeah, we can be flexible with that.
Okay.
Yeah.
Any other questions?
What about for certain things, say an automobile or a maybe a checking account? Is it worth putting somebody else's name on that account so that when you pass away immediately, I mean, you have to basically trust that person
Right.
if you're giving them access to your account, but initially, I mean, instantly when the person dies,
Right, that will be their asset.
that would be something that the living person could use, or they could immediately go to the DMV and say, this is my car, I can continue to use it,
Yeah.
versus if a person dies and they have
Right,
a car,
having to
it
be
can't be
designated.
used any longer, right?
Yeah, that certainly might help avoid probate as long as they are alive. The other thing I always want people to just be mindful of, especially for bank accounts when they're talking about that, are tax complications. Same with real property too. If you end up in a situation where you're co-owning a property with your son or daughter, and then like homestead exemption and all of that and how that
Right.
works, there can just be tax implications. So you just want to think through that too. But yes, I mean, there are circumstances. Katie doesn't always agree with me on this, but if I've got somebody that comes in, I said they're, somebody who's 90, they own real property, there's an enhanced life estate deed in favor of their son, and their son is on the checking account with her and a car, I don't think she needs a trust in all likelihood, but really barring very limited exceptions. You're just going to get much more comprehensive coverage with a trust. And the other thing I didn't say, which I should, again, only I can't speak to other firms, but at least at our firm, if we were going to prepare a comprehensive will versus a trust with a pour over will, you're saving maybe a few $100s, and you're going to get so much more protection with a trust. It's going to plan for all of those what if scenarios and the circumstance or the example you just gave, so you put your son on the car with you. What if you're in a car accident together? You've avoided nothing because then there's probate involvement for that. Same with a checking account. Whereas with a trust, it could plan for all of those what if scenarios that just careful beneficiary designation isn't going to get you to.
Although you may have said this, you can put someone as a beneficiary on your vehicle. So my husband put himself as joint owner on his mom's car, and I made him go right back and switch it to beneficiary.
Right.
So I was like, that's a really bad choice, which he did. So when she passed away, because all she had was a bank account and a car. So like that's a good scenario
Where you don't need a trust.
where you don't need a trust.
Yeah, and the reason you probably picked up on this, that you don't want to necessarily be a co-owner, at least with Katie's mother-in-law, God rest her soul. You don't want the liability of that. So that could be a problem. But I was avoided. Any other questions? Thank you all for spending your Monday, or no, today's not Monday. I don't know what day we're on.
I don't know. No, it's Wednesday.
I know.
Yeah.
Don't pay any attention to me. It's been a week already. I guess
thank
the
you for
rain
joining
has
us.
held out, but thank you for joining us.
Thank
I
you.
appreciate
Thank
it.
you.
And we have cards if anybody has would like to take a card, or if there's any questions, please feel free to give us a call.
Thanks.
Thanks.
Good refresher for me.
Have you finished yours?
I know, we not funded yet, she
Maybe
needs to
in
just
the-
do that.
I
know.
Yes.
Yours is, you have a lot in there though, your businesses and all that.
Yeah.
How many decades?
Yes, funding. Funding's so important.
But you know
So
what's really fun?
So I'm
Getting
going through it.
like generic spam mail to address to the trust.
oh, funny, weird.
Yeah, we got something that, well, cause mine is the Humanified Trust.
Oh, right. That is hysterical. That's so funny.
Does anyone more Seinfeld or no Seinfeld?
I'm so thankful
Yeah,
that
the Human Fund, George's, yeah. So instead of it just being Catavangelo Trust, I was like, we're just gonna make this something silly.
That is so
I like
funny.
I'd probably do that.
That is so
Right,
funny.
Keep people guessing. It makes life interesting.
Yeah, you have to fund the trust. My husband is a banker, and he was dealing with someone last week who, it was a son, and the father died that week, and he was there to like deal with the trust stuff, and the father never funded the trust. And he's like, but my dad set up the trust and did all of this to avoid probate. And my husband's like, I'm really sorry, but everything is still in his individual name. So the dad never did any of the funding, but paid and set up the trust, but didn't put anything in the trust.
I know.
So fund your trust.
In my defense, Chris said he was going to take care of it.
On this, Chris.
So I'm texting him right now.
What does it mean, fund the trust?
Putting the like.
Oh,
So,
listing all the assets?
yeah,
this
like
out.
titling your assets in the name of your trust,
Yep.
We gotta do it.
which is step 2. So once
I
the
see.
trust
Yeah,
is
yeah,
set
yeah,
up,
yeah.
yeah,
You have to actually add names to these
Correct.
things?
Yes.
yeah,
I know,
Contact.
I'm
Yeah.
confused, like.
So it's pretty fair to assume
Don't
that
make
if
me make.
my husband and I came to you and we're like, hi, we have nothing,
I know,
you would
me-
just do everything. Like, we can pay you to do everything, that's what you're talking about.
yeah. Like we would ask you. Like a lot of people are like, well, I don't have anything. But then we ask you questions, and you're like, oh yes, I have this. I
She
have.
means like she don't want to have to fund anything.
Oh yeah, we would do it for you.
We have
Yeah.
no plans.
Yeah. Yeah. For us, it's just very factual.
Yeah, just said, really.
No, it's 30, so
When
$100
we
million
talked, then
dollars
they
in
sent
the
us
back.
home, they sent us home with like a package.
Thank you.
Thank you for coming. Yeah.